but the government failed to meet its burden for a separate reason. There was not substantial evidence as to Mr. Maria Lopez's knowledge of status. The evidence on this point was mixed, and the government points to an uncorroborated statement, which cannot carry the government's burden. For these reasons, we would ask the court to hold the government to its burden and find in Mr. Maria Lopez's favor. Turning to the first point on suppression, there was no reasonable articulable suspicion that warranted an investigatory stop of Mr. Maria Lopez. It is well established that officers must articulate reasonable, specific facts that cut out a substantial portion of innocent travelers. Here, the facts leading up to the investigatory stop are critical in that regard. As the court is aware, several residences were under review, and at those residences, officers happened to locate, according to page JA 25, 2 individuals who met the general description of the cruise warrant, that is, Hispanic males with short black hair. However, at that time, officers could not make a positive identification as to whether either of them was Mr. Cruz. Therefore, officers then proceeded to trail the individuals for over 70 minutes in the vehicles. During that time, not even so much as observing a traffic infraction on which to make the stop. They also ran the plates of the vehicle during that time, determining the vehicle was not registered to a Mr. Cruz, but rather to a Mr. Maria Lopez. And there's no reference in the record as to any relationship between these parties. Nonetheless, officers decided to proceed at that point and complete the investigatory stop, as reflected on page J846, on the, quote, hopes of locating the suspect. This does not establish reasonable articulable suspicion, Your Honors, where effectively the officers attempted to use a warrant for person A to duck the reasonable articulable suspicion requirement for person B. This was explained and illustrated, Your Honors, in United States versus Hudson out of the Sixth Circuit. In that case, the officers were looking for a black man who was the subject of a warrant. The officers knew that this individual, based on some information, would be in a particular place, with a particular woman, in a particular vehicle, and at a particular time. Officers proceeded on that information in the attempts to locate this individual. And of course, at that time, they saw the vehicle. They saw that the woman in that vehicle. However, they saw 2 black men in the vehicle with that woman. Officers did not attempt to make any further positive identification of the individuals, but decided to proceed forward nonetheless. They did locate the individual, but on appeal before the Sixth Circuit, the Sixth Circuit explained that that did not create reasonable articulable suspicion because the officers effectively went off of a subjective hunch because
Can I ask you a question? Of course, the district court relied on cases in our circuit, and you may disagree with the way the district court interpreted them, but at JA 184 in the district court's order, the district court says that we, the Fourth Circuit, has previously held that descriptions as or even more generic than the one here at issue can properly contribute to an officer's reasonable articulable suspicion, and it cites for that proposition our decision in Humbert. What's wrong with that analysis?
What's wrong with that analysis, Your Honor, is one of the cases that the court cited specifically gets into the type of vehicle and the make that was before the officers at that time. There aren't any specific descriptions beyond Hispanic male with short black hair, few specific residences, and traveling with other Hispanic men.
What about the fact that there was, I guess, that the officers understood, I think, that these were alleged MS-13 members? Does that add anything to the analysis?
Respectfully, no, Your Honor, because as stated in United States versus Black by this court, reasonable suspicion by association is insufficient. And that's exactly what's going on here, Your Honors. Effectively, law enforcement saw several Hispanic men. They knew they were looking for a suspected MS-13 member, and they believed on that basis alone that Mr. Maria Lopez or the other individuals might have been MS-13. But that was not known at the time, which is the critical analysis.
You agree? So I don't know about the case you cited from the Sixth Circuit. This officer testified that he had seen a picture of the individual for whom there was a warrant, right?
That's correct, Your Honor.
He said, when I look, I'd seen a picture, and then when I looked at the individuals coming out of the, this is at J114. He said, did what you'd seen in the picture eliminate the individuals you'd seen? And he said, no, right?
That's correct, Your
So I
Honor.
don't think we can just say it's Hispanic men with short hair. It's Hispanic men who look sufficiently like the person I saw in a picture, and it didn't eliminate him, right? So I don't. You say over and over again, it's literally just Hispanic males with short hair. I don't think that's accurate based on the record.
Well, Your Honor, looking specifically to the photo did not add anything or move the ball forward for the government.
It does. Sure, it does. If I look at a photo, and then I look at other people, a lot of people, I'm going to be like, that's not the person I saw in the photo. That's not the person I saw in the photo. That's not the person I saw in the photo. And here the officer said it did not eliminate him as the person I saw in the photo. That seems like it moves the needle quite a bit, actually.
Respectfully, no, Your Honor, because
Really?
the government's burden is to determine if this individual is the one who was
No.
located.
It's the government's burden to determine whether there's specific articulable reason to believe this might be the person, not whether it is the person.
Correct, Your Honor, but in broad daylight, middle of the day, the officers were looking at the photo and looking at the individuals who came out of the residence, determining two of them might have been the individual, but they took no steps further.
It just seems like that eliminates a lot of potentially innocent people. You came out of a building where I had reason to believe the person I was looking for is. I'd seen a photo of the person I was looking for. I look at the guy and I think, I can't say it's not the guy I'm looking for. That eliminates, it strikes me, a rather shockingly large number of innocent people.
It might eliminate several, Your Honor, but it doesn't.
Several?
Well, Your Honor, looking to the census records for Sterling, Virginia, 47% of the demographic is Hispanic. That is to say,
You mentioned earlier that they surveilled the cars for 70 minutes. How many times did they stop? And I know there's some discussion in the record as to they weren't sure as to what they were doing, but they were stopping, getting out of the car, getting back in the car. And how many exact stops were there?
there were two, Your Honor, I believe. There was Walmart and Sunoco, and they moved between the vehicles, as would be fairly standard when going between vehicles and determining which individual you want to ride with to the next stop. But there's nothing in the record as to indicate what those moving between the vehicles meant one way or another. Moving back to the standards here, however, there was also no reasonable, articulable suspicion that Mr. Maria Lopez was armed and dangerous. The most express evidence that the court had before it of this was Deputy Alley's testimony. He stated that he himself did not believe Mr. Maria Lopez was armed and dangerous.
So why does that matter in terms of the stop? Because they had a warrant, right? And assuming that they were able to narrow the universe of folks, and you responded to Judge Hyten's questions with demographics regarding statistics of Latinos in the area. But the point is that, and you may, obviously you disagree with this, that they believe they had narrowed the universe of potential suspects to a number of residences, and they had seen the photos. So anyway, what does armed and dangerous what does armed and dangerous have to do with it?
Armed and dangerous matters at that point, Your Honor, because the law enforcement after this located the satchel and the firearm in the satchel.
But in terms of the stop,
yes.
what does that have to do with?
This moves us past the point. So on suppression, there being reasonable articulable suspicion for the stop, and then the reasonable articulable suspicion for the search.
Okay.
So
But isn't the fundamental problem here the district court found as a factual matter your client consented to this? And if he consented, none of this matters, right?
it's correct, Your Honor. The lower court found that Mr. Maria Lopez consented.
And so before we can even get to the merits, we have to find that finding is clearly erroneous, don't we?
We do, Your Honor, and we believe it is clearly erroneous. Looking to the facts of the stop on the body cam footage, when Deputy Alley takes the satchel and opens it, he exclaims certain expletives in surprise, as if he was surprised to see the firearm in the first place. But moving on to the consent aspect for Mr. Maria Lopez, there was a language barrier known, again looking to the body cam footage, from the very beginning of this stop. After the very first question that officers asked during the stop, Deputy Alley and the other officers asked for, "I need Spanish," meaning that they were looking for an interpreter at that point. They recognized there was a language barrier and they proceeded nonetheless. There was also gesturing accompanying all the questions that was asked, as if that would somehow aid in the comprehension. They also asked questions in English and in Spanish, but critically, all of the consent questions were in English. All this going to show that there was a language barrier from the start, and officers proceeded nonetheless. Taking a step to the next issue, Your Honors, the government also failed to meet its burden as to the sufficiency of the evidence. There was not substantial evidence as to Mr. Maria Lopez's knowledge of status. The government was required to show status, that Mr. Maria Lopez was an illegal alien, and then separately, knowledge of status, that Mr. Maria Lopez was aware that he was an illegal alien at the time of the stop and at the time of the possession of the firearm.
Can I just, I guess I'm probably inclined to say this isn't waived because the district court didn't cross all its I's and dot all its T's, but you are really lucky the government didn't cross appeal this.
Your Honor, this issue was not waived. Looking to the facts at the sentencing hearing.
Oh, I know, but I think it's unambiguously clear that your client was given a lower sentence by the district court based on the district court's understanding that we weren't going to be here raising this argument now. And now you are, so I think there's a more than plausible argument the district court would have given your client a higher sentence had the government cross appealed.
Well, Your Honor, looking to the transcript specifically and the burdens at sentencing versus at trial, any statements that Mr. Maria Lopez made at sentencing would be the court would be finding those facts to a preponderance of the evidence.
I'm just saying if I was the district court, I would be extremely angry at you right now because I would feel like I sentenced this defendant based on a false representation about what was going to come up on appeal and what wasn't.
Understood, Your Honor. But looking to the facts, the court was required to question the Mr. Maria Lopez to ensure that any waiver was voluntary, and that is simply not reflected on the facts.
I think I probably agree with you about that.
Yes, Your Honor, and if we could point the court specifically to perhaps the most telling statement made on JA 601, when the court is going back and forth with the defendant on status and knowledge of status, the defendant states to the question of, were you here illegally? Well, I didn't really understand that it was a crime to be illegal. I did not really understand the meaning of the word illegal until they told me the meaning. Again, the government's burden was to show at trial, beyond a reasonable doubt, that Mr. Maria Lopez knew at the time he possessed the firearm.
Why wasn't the following sufficient? First of all, an officer testified that your client said he knew he was in the country illegally, and then you're going to say that's the uncorroborated testimony. But it's not uncorroborated because, as the district court pointed out, there's no evidence that he entered the country. He's not, as far as we know, he's clearly not a natural-born U.S. citizen. There's no evidence that he entered the country legally. That is indirect evidence that he knew he entered the country illegally. There's the fact that he expressed concern about handing over certain identification, expressed no concern about sort of ping. All of that seems like circumstantial evidence of knowledge of illegality. And whether you think it's good enough or not, it's not just his testimony. There's a whole bunch of other circumstantial evidence that indirectly could support an inference he knew he was in the country illegally. Why isn't that obviously enough?
It's not enough, Your Honor, because taking a step back on an initial point, Mr. Maria Lopez came over as a minor, and it's very routine.
Sure, so that evidence is not that strong.
Right. As to whether Mr. Maria Lopez knew he was illegal or not, that information on turning over identification or the facts of how he might have come over do not explain his knowledge of status, because as stated by the government as stated in the record, the information that the government points to is the lack of the A file, the lack of identification, the Salvadoran citizenship, not wanting to give up his father's information for fear of immigration repercussions. But none of that goes to Mr. Maria Lopez's knowledge of status. If the government had wanted to introduce evidence of Mr. Maria Lopez's knowledge of status, it should have followed United States versus Rodriguez-Soriano. That is, introducing testimony that could corroborate Mr. Maria Lopez's statements that, if taken in the light most favorable to the government, were that he stated he was illegal. All that to show, Your Honors, we ask that the court find in Mr. Maria Lopez's favor and hold the government to its burden. Thank you, Your Honors.
Thank you, Ms. Bryant. We'll hear from the government.
Good morning, Your Honors, and may it please the court. Daniel Honnold for the United States. I think I'll just start where my friend started with the Fourth Amendment issues. The district court didn't err in denying the motion to suppress here. First and foremost, the stop that was conducted was a reasonable execution of an undisputedly valid arrest warrant. The officers had taken steps, investigative steps, to significantly narrow the scope of who they could permissibly stop that day.
You think it matters that they followed him for 70 minutes? They stopped twice, getting in and out of the car. He had a picture as to reasonable suspicion, and also the second portion of that is criminal activities afoot. I believe Deputy Alley said that he had no idea whether or not they were armed or he didn't think that he was armed or dangerous, and he did not know of any criminal activity within the 70 minutes that he followed him.
No, Your Honor. The lack of personally observing any criminal activity or indicia of criminal activity during that time span is irrelevant to the propriety of the stop here. There's two different sort of areas of Fourth Amendment doctrine that I think we need to separate out to fully understand this. The first is the warrantless Terry stop, where officers do need reasonable, articulable suspicion that criminal activity is afoot or has been completed in order to, or is about to occur, in order to conduct a warrantless stop. The other body of law that we need to really be looking at and focused on here is, did the officers have reason to believe that one of the people they were stopping is the individual named in an arrest warrant? When you're in that body of case law, which is what we have here, you don't separately and independently need to also see someone, be about to commit a crime in order to lawfully stop them.
But does it make a difference that they followed them for 70 minutes?
No, Your Honor. They
had a picture of Mr. Cruz. They had a picture of Mr. Cruz. They followed him for 70 minutes. They got in and out of the car. And even when he walks up to him at the gas station, he has a photo of Mr. Cruz. And I believe the testimony is that he knew at that point he was not Mr. Cruz.
No, Your Honor, that's not correct. At that point, he did not know whether or not the driver was or was not Mr. Cruz. And it's completely reasonable for him to think that. He doesn't know the person personally. And if you were to look at the arrest photos of Mr. Murillo Lopez and Mr. Cruz at JAA 44 and 156 respectively, frankly, they look quite similar to each other. It would be very reasonable for an officer to need to want to conduct further investigation to ascertain that person's identity. So it is not the case that either the officer testified that he believed or had reason to believe that the driver was not Cruz. At that point, he still didn't know, and in fact did not come to learn Mr. Murillo Lopez's identity until after the recovery of the firearm. So up until that point, it was still quite plausible that the defendant was Mr. Cruz. He turned out, in fact, not to be, but that does not affect the propriety of the stop here on this record. I'll just turn back to, in line with the photo, the officers also conducted an investigation to learn the whereabouts of Mr. Cruz, the arrest warrant suspect, and took efforts to stake out one of the residences. I'll just point out for the court at JA 88, I believe Deputy Alley describes that home as a townhouse. There's no evidence that it's occupied by multiple families or anything like that. It's certainly not some large apartment complex where any number of people could be walking in and out.
Right? Isn't the testimony that there were multiple properties they were surveilling?
So the factual finding is that the officers had obtained information that Mr. Cruz was at one of few addresses on the same block in Sterling, Virginia. There's no testimony or evidence really about the number of potential addresses. There's no evidence that the officers had staked out other addresses around the same time. The only evidence that we have is that the officers were staking out the specific address where they saw Mr. Cruz or saw an individual who they would later come to understand was Mr. Cruz, who matched the description of Mr. Cruz, come out. But all that to say that, again, this is not a large scope or scale of potential suspects. This eliminates the vast majority of travelers.
It's the geographic limitation that sort of makes this case different than, because the description itself is fairly generic, right?
Your Honor, when it's paired with the photograph, I would disagree. Having the photograph that the officers had access to and were able to see, seeing a photograph, it's, a picture's worth 1,000 words. It gives a lot more information than simply Hispanic male short hair. You can see someone's age, you can see their, the size of them, many other physical characteristics that are going to be above and beyond the description that was also presented here.
It seems to me that some of those cases that say the description is insufficient are literally like someone calls in a person of a certain race, sometimes like a vague description of their clothing, sometimes a vague description of their height.
Correct.
And those are the cases that we say like that. That doesn't eliminate like a lot of people.
Correct, Your Honor. But here we have several really significant things that the officers are doing before they make contact to help to narrow the scope of potential people who could be stopped. Unless the court has further questions on that, I'll turn to the frisk. As the court noted with my friend, I think the easiest, path here is probably on the consent front. The only dispute that is raised here on appeal is whether or not the defendant had enough English language understanding to be able to validly consent. There's no other challenge to the validity of the consent here. And that finding was subject to a clear factual finding by the district court that the defendant did, in fact, understand enough English to be able to consent here. It's really hard to show clear error. There's nothing in this record that's going to really demonstrate that the defendant did not understand enough English based on the conversation that he had with Deputy Alley and what's visible on the body-worn cam.
What about in the beginning, when he first approaches the car, he asks one question, and then he turns around and say, basically, hey, I need an interpreter over here. Is that not sufficient?
No, Your Honor, that's not sufficient. Two things. The Deputy Alley had a significant interaction with the defendant before Detective Fields, who is the person who's got the body camera on him, approaches. So there's a significant portion that's been asked about and was subject to cross-examination at which Deputy Alley testifies the defendant had not even a little bit of trouble understanding him in English. Then Detective Fields, as you were mentioning, approaches with the body-worn camera. It's Detective Fields who says, I need some Spanish. He says it in kind of a joking way. They both kind of laugh about it. It's clear
What
that...
about the hand gestures? He's asking him if he's going fishing. I mean, it's clearly some language barrier going on there between the deputy and Mr. Lopez.
So I don't think it's fair to characterize it as a language barrier. And of course, Deputy Alley is making that gesture about going fishing after the defendant had responded to him in English, fishing. He didn't say that. He wasn't using that gesture to help the defendant answer. He was merely repeating back to him what the defendant had told him in English. So no, there's not going to be enough here to show a clear error of factual finding as to his level of language acquisition. And there's no case law that I'm aware of that says a minor language barrier is going to be enough to show clear error. There's no case law that says that the person has to be a native or completely fluent English speaker in order to be able to validly consent. He just needs to understand enough. And that's what we have here. So that's going to cover both, of course, the pat-down and the search, which isn't separately challenged. If this court were to disagree, we could still move to the merits of the Terry frisk. Of course, there is reasonable articulable suspicion to believe that the defendant was presently armed and dangerous at the time of the pat-down. The officers have all the information that they have about the suspect that we've mentioned before, plus the appearance of the satchel, which is sagging forward with a significant amount of weight, which caused the officer at JA 119 to believe that the defendant was presently armed. It's an objective analysis. All these arguments about what Deputy Alley may or may not have believed are simply not going to be relevant for this court's analysis.
I thought and I'm looking, JA 100, 118, that Alley testified that there was nothing in his interaction that made him think that he was armed and dangerous.
So we need to put that statement in a bit more context, Your Honor. Deputy Alley testified that at some point in the interaction, he came to subjectively believe for some period of time, because of the defendant's demeanor and rapport that they had, that he may not have been armed. But the real question for us, the real analysis that we have to do is, at the time of the contested action, which is the pat-down, did the officer have reasonable articulable suspicion? So there's two things here. One, his subjective impressions are irrelevant to that legal question, but even if the court were to consider them, if you look on JA 119, the question is very, very clearly asked and answered. At the time of the pat-down, did you think he was armed? Yes, I did. So whatever Deputy Alley may have thought at one point in the interaction, that's not, both legally and factually, that's not going to bear on the ultimate outcome here. I didn't hear my friend address the Second Amendment challenge, so I'm happy to rest on the briefs on that unless the court has any questions about that. Our view is that, of course, that it's waived for having been untimely filed and the defendant can't show plain error, but I will not spend any time on that unless the court has any questions.
I realize we've said waiver in that context. Doesn't it seem pretty obviously forfeiture, not waiver?
Your Honor, it has been repeatedly waiver over and over again.
I know, but we say things are waived when we really mean forfeited all the time, just kind of like we say things are jurisdictional that are clearly not jurisdictional.
Your Honor, I think some of that confusion has been cleared up in recent years. I mean, Ojedokin, I think, was from 2020. This court in Sanders, I think just a month ago, re-invoked waiver by citing Rule
Yeah,
12.
but conceptually, how would that possibly be waiver? Like, it seems like it's the definition of forfeiture, the failure to make a timely claim of a known right. That's literally the definition of forfeiture.
I understand that, Your Honor, but it's this court's case law
I know.
that says that. And also, I think there's a fairness rationale behind that as well, for two different reasons. Is this a known right? Yes, it's Rule 12. You know that as a defendant that you have the ability and the obligation in a timely manner.
The same is true when I don't raise a Miranda objection or when I don't raise a Fourth Amendment. Like, there's like a gazillion objections like that.
Well, Your Honor, the failure to raise a motion to suppress is going to be a waiver on appeal as well.
When I don't object to hearsay at trial.
Well, that's different, Your Honor, because that's not subject to Rule 12, and there's no good cause sort of exception built into that.
So maybe I'm missing something here, but why does that matter to you? Waiver, forfeiture, you still win.
We're happy to win either way the court wants.
Fair.
The court sometimes.
Yeah, that's our problem, Mister. Not yours.
It's a good problem for the government to have at this point, and
So
we're
can I
happy
take you to the
either way.
sufficiency?
Yes.
First, this is more of an informational question than anything else. Do you think you could have cross-appealed this sentence in response to this appeal that seems at least, at minimum, very inconsistent with representations that were made to the district court judge?
I think the remedy that we're seeking here.
Well, you didn't cross-appeal, so I think this is purely a could you have.
I haven't thought about it, Your Honor, and I don't know the answer. I'm sorry.
I don't know the answer either. That's why I was asking you.
We would be seeking to disturb the judgment, so I think it would have to be subject to a cross appeal if we wanted to get a resentencing based on these representations or misrepresentations at the district court level.
Okay, so let me go to the question that you think that this is forfeited or waived or whatever. During the plea, so for example, so the hypothesis is, I think there's no question the defendant did not personally say the most critical thing. The argument you have is that the lawyer said the most critical thing. And I get, generally speaking, lawyers can agree to all kinds of things for their clients, but I actually think this might be one of those that they can't because, so for example, you agree that you couldn't during a plea colloquy rely on defense counsel to say, my client is knowingly and voluntarily doing this, right? That's the kind of thing that has to come out of the defendant's mouth personally, right?
Yes, Your Honor, but I'll remind the court that those require that dynamic is subject to Rule 11. Here we've got sort of, and that's, in the context of someone waiving their rights to trial, their rights to cross-examine witnesses, their entire right to appeal everything. This is the waiver of a single discrete issue, which I think is fairly uncontroversial.
It's a waiver of an issue of whether I'm guilty of one of the crimes I'm charged with, right?
Yes, Your Honor, but that's true of many challenges, right? I mean, we wouldn't be raising challenges unless they would affect either the sentence or
No,
the
this one
ultimate
isn't
conviction.
indirect. This isn't like, I raise this challenge which results in the exclusion of evidence, which results in me being acquitted. This is me admitting to guilt of a crime, right? This starts to sound a lot more like Rule 11 to me.
Well, so it's not Rule 11.
I know it's not technically Rule 11, but it.
And I'll just, I don't think there's any legal distinction in the doctrine, in the case law, for the proposition that it has to be the defendant personally that waives the issue in this particular context and not in the myriad other contexts. Right. Well,
It seems quite a thing to say that a lawyer can essentially admit their client's factual.
so, Your Honor, the waiver is not to the admission of factual guilt. The waiver is of the ability to raise this particular sufficiency challenge on appeal. That's what's being waived. So that's kind of a different thing.
It's like an appeal waiver.
It's like an appeal waiver, or it's like when a defense attorney, as often happens, will withdraw an objection to, for example, a sentencing enhancement at sentencing. There's no, real Rule 11 colloquy that's happening there.
It can dramatically increase.
Exactly, Your Honor. These things can have large consequences for defendants. Defense attorneys are the agents of their clients, and they are able to waive issues even if they're not being specifically pressed, personally the defendant, on whatever that waiver is. And I'll just remind the court, if the court were to look at JA 587 through 604, the defendant is intimately involved in this entire colloquy, even if he doesn't answer the ultimate question and his lawyer answers it for him. He's being questioned back and forth with the judge. They take a 10-minute recess for him to discuss with his counsel the consequences of this very issue, and then he comes back.
The judge said, this is really, really important to me, and I want to give you a chance to talk to your lawyer about it.
Right. So, I think the record is quite clear that the court gave a really significant opportunity for the defendant to personally to knowingly understand what he was giving up by doing this. And of course, at the end, the district court is telling defense counsel in defendant's presence, you're not going to be appealing this issue. Defense attorney says, I understand. He doesn't say anything. He doesn't express any surprise or any disagreement with that notion or says, no, wait, I'd rather not get acceptance of responsibility so I can preserve this issue on appeal. I think just taken, as Your Honor was mentioning earlier, from the district court's perspective, I mean, how would a district court feel if they were to read this opening brief after the colloquy that he had with this defendant? I think this is, sort of the ultimate example of taking inconsistent positions on issues below and on appeal, and that this court should not be able or should not countenance that.
Well, let's assume for the sake of argument we've reached the merits. Would you just tick through what you think are the two? So I think we have cases that say like his word alone cannot be the sole evidence. What do you think are like the 2 or 3 best corroborating things in the record that could permit a reasonable fact finder to find that he knew he was in the country illegally?
Yes, Your Honor. I'd say Officer Perotti's investigation, the review of the relevant government databases, we're trying to prove a negative. He's not a citizen. So if the court were to look at JA 319, I think Officer Perotti has a really good summary of his investigation. He says, I've looked at all the databases. I've reviewed all the things. I've interviewed the defendant. There's nothing in my investigation that's turned up either the possibility of citizenship in the United States or any lawful status or presence to be here.
And that's indirect, that's indirect evidence of what he knows, right? Like the fact that as far as we can tell, you're not in the country legally is itself indirect evidence that you know.
Yes, Your Honor. I found this to be a really interesting point. I think we can take some guidance from Greer here. In Greer,
The person who's a felon usually knows they're a felon.
Right. And someone who's crossed the border illegally, has remained here illegally over the course of several years, has never had any viable claim of confusion or actual right to be here, they're going to know that fact about themselves. And a jury is fully entitled to make that reasonable inference. I guess our position, when you frame it that way, is even if you were to take out all the defendant's statements, there would have been sufficient circumstantial evidence of the defendant's knowledge. You tack on the fact that he tells Deputy Alley, I'm not a citizen, I'm illegal. That's at JA 261 to 262. It's hard to know what better evidence you could possibly want for someone's knowledge than for them to say, I have that status, I am illegal. He knows that fact about himself. So it's not correct to say that this case was premised entirely on an uncorroborated confession. It's not even dependent on that confession necessarily. There's sufficient evidence without it. There's excellent evidence with it. If the court has no further questions, we'd ask that you affirm.
Thank you, counsel. Ms. Eichhoff?
Your Honors, and may it please the court, Ashley Eichhoff on behalf of the appellant, Mr. Maria Lopez. I'd like to first return to what the court was just talking about with the government, and the government misrepresented the elements of the offense here. The government has to prove status and also knowledge of illegal status. The government did not present sufficient evidence as to knowledge. And the record site that the government just gave you at JA 262, that interview with Officer Parody was after the stop. The government has the burden to prove that he had knowledge of his illegal status at the time that he possessed the gun. The fact that he knew that he was illegal afterwards does not prove anything as to status.
How far after the stop?
Was the testimony with Officer Parody?
Years or like a day?
I don't know that off the top of my head, Your Honor, but it was...
Can't a jury find that if you knew it when you spoke to an officer shortly after, you probably knew it before you were arrested too?
No, Your Honor, because that directly...
Really?
It directly contradicts Rodriguez-Soriano, which says that this court cannot find that any statements of the defendant, uncorroborated, can represent the corpus delicti of the offense.
No, I agree with that. It can't be the only evidence, but it certainly doesn't have to be none of the evidence either, right?
But all of the evidence presented...
Virtually every defendant who confesses guilt is confessing knowledge of something that happened in the past, right? Like when I say, I killed my friend last week, what I'm actually saying is, today I remember killing my friend last week. That doesn't prove that I intentionally... But it's pretty... The fact that I remember it today is pretty powerful evidence that I knew it then, right?
All of the evidence the government presented goes to status, not his actual knowledge.
No, him saying, I know I'm in the country illegally goes directly to knowledge.
Again,
I agree that can't be the sole evidence, but I don't agree with you that it's not any evidence.
it can't be used as the sole evidence, Your
I agree
Honor.
with that.
So turning,
What about the government's point, the sort of the Greer point? A jury is entitled to find that just like a person who's a felon normally knows they're a felon, a person who's in the country illegally normally knows they're in the country illegally.
I think with a felon, the standard is much different, Your Honor. With illegal aliens, many illegal aliens are brought to this country as children, just like Mr. Maria Lopez was in this case. He was brought to this country by his father, which is shown in the sentencing allocution at JA 601, which Ms. Bryant previously read to you, where he stated that he did not know that he was in this country illegally and did not understand what it meant to be illegal. That's just like many dreamers. That's why we have DACA.
Like a lot of criminal defendants, he said, I didn't know. And like a lot of criminal defendants, the jury is entitled to not believe him when he says that, right?
Yes, Your Honor. So returning first to the stop itself, we have cited many warrant cases where they're also found that there was no reasonable articulable suspicion. The government seems to think that we should ignore warrantless cases, but even if that's so, we have cited warrant cases. For example, Hudson was a warrant case in this court and this district, in the circuit, I mean. Slocum was also a warrant case where even with a warrant, the court still found that there was no reasonable articulable suspicion, and they did not have that here.
So the government relies heavily on the photograph as sort of, in addition to the other facts, skimp as they are, to narrow the universe of people that might be subject to the stop. What's your take on the significance, if any, of the photograph?
Your Honor, I'd like to point this court to JA 89, where Deputy Alley testified, well, we knew the license plate of the blue Ford Explorer, which came back to someone registered Mr. Maria Lopez, and the detective whose case the armed robbery was, and he knew the address or the area of addresses were associated to the target. That's about it. There was no testimony into the record that they thought, that they knew that he was Mr. Cruz. In fact, that they said the opposite.
Well, I mean, but the photograph exists, right? And they had the photograph. They may not have focused on it then. I'm asking you what, if anything, why isn't that significant? At least some additional evidence that a district court could take into consideration in deciding whether or not there was enough to justify the stop here.
I would turn you to JA 156, which is a photo comparison between Mr. Cruz and the appellant, Mr. Maria Lopez, which shows that they bear little resemblance to each other. And also, Deputy Alley testified that he did not know whether Mr. Maria Lopez was Cruz at the time that he approached the car. In fact, he said that he hoped that they would find the subject of the warrant, and that is exactly what this court found insufficient, what the Sixth Circuit found insufficient in Hudson, which is that the mere hopes of finding a suspect of a warrant is not enough. And for those reasons, Your Honors, we ask that you find for the appellant, Mr. Maria Lopez.
Thank you very much. Ms. Bryant and Ms. Eichhoff, I see from the record that you all took on this case with your law firm pro bono. I want to thank you for ably representing Mr. Murillo Lopez this morning. You did a fine job, and Mr. Hano, you did an excellent job as representing the interests of the United States. So I want to thank all the lawyers here this morning. We'll come down and greet you and then move on to our second case. Our final case this morning is 23-4572, United States versus Bowling. Mr. Yost?
May it please the court, Honorable Justices, my name is Brian Yost, and I'm here today representing the appellant and defendant below, Mark Bowling. This is a case that began back in September of 2020 when Patrolman Farley, a 20-year-old with 1 year experience on the police force, was monitoring traffic on Interstate US 19 in Fayetteville, West Virginia. Also that night, there was another individual there by the name of Deputy Garrettson, who was also monitoring traffic at the same time, and 2 vehicles were pulled over. Farley happened to pull over a vehicle driven by Mr. Bowling. Once he pulled him over, he advised him that he clocked him going 68 miles per hour, and of course we haven't challenged the stop itself, but he asked for the driver's license, registration, and insurance information. He claims Mr. Bowling was unable to provide him his driver's license. Mr. Bowling testified that he did in fact provide his driver's license.
And the district court believed who?
And the district court believed Officer Farley, that he found that Officer Farley was credible on that issue. However, the CAD report, I would note, there's clear evidence that in the CAD report that 1 hour and 15
Have you
minutes.
challenged that finding is clearly erroneous?
Yes, I would say it is clearly erroneous. The finding that was refuted in the CAD report, and on cross-examination, Mr. Officer Farley, when confronted with the CAD report that showed that the license number was run, not Mr. Bowling's name at that time, he stated then, well, I don't remember receiving the license at the beginning of the stop. But in any event, he did not provide the registration and the proof of insurance. That is accurate. Mr. Bowling apparently told him that it was in the car. He didn't want to look at it look for it in the middle of the night. But nonetheless, at the time of the stop, he ran the license plate, and the registration information came back immediately, within 3 minutes. The stop was at 2:52 in the morning, and at 2:55, he had the registration information on the vehicle showing that it was a rental car and that it was an enterprise rental car from EAN Holdings. So he would have had that information if he had just continued following the purposes of the stop, which he didn't do. He immediately, upon stopping the vehicle, he had Mr. Bowling step out of the vehicle, took him to the back, and the next thing he did was ran the information on the backseat passenger. He did nothing with Mr. Bowling's information, but he took a backseat passenger, Samuel Burdett. He ran that information to check to see if he had any warrants out for him, and just did an ID check, and it came back that he had an expired ID and there were no warrants on him. That completed everything related to the actual stop without ever running any information on Mr. Bowling or on the front seat passenger, Mr. Smith. He just then moved on after getting this information back 8 minutes into the stop, about 3 o'clock. He knows that there's no outstanding warrants. He just begins questioning Mr. Bowling at the back of the car. And he decides at some point he's going to get a canine. So he starts trying to get a canine. At 3:12, he calls. Now this is...
At what point did he notice that there was a problem with the cover and the steering wheel?
He noticed. He testified that he noticed that there was a problem with the steering wheel immediately. He did it.
What are we to make of that? Was that heightened suspicion?
I don't believe that's heightened suspicion. I don't think it's... Look.
Really bizarre.
Well, it's odd, but airbags deploy. I just recently had an airbag deploy in my vehicle in an accident. That's not unusual for an airbag to deploy, and then it's just hanging there and cut out. I've seen vehicles with that. I don't believe that is necessarily any indication that there's criminal activity going on, that an airbag had been deployed. It's just an indication that at some point there had been a collision.
Wasn't the
with that
airbag
vehicle.
cut out?
Huh?
Wasn't the airbag cut out of this? Not just that it was hanging there, it was cut out.
No, yeah, it was cut out. That's what I'm saying. If it's not, it wouldn't be unusual to cut it out because otherwise the airbag just hangs there, and so.
Well, but I guess what that does suggest is it didn't just happen, most likely, right? I mean, it'd be one
Correct.
thing if it's like just hanging there, like maybe it happened 10 minutes ago, maybe it happened this morning, maybe I'm driving it to the mechanic, but the fact that it's cut out suggests that it didn't just happen.
Right. That is true. But I don't think it is any indication of some kind of criminal activity that's taking place.
Well, but the fact that it's a rental car just adds sort of to the mystery, right? Because you'd think a rental car, would assume a rental car wouldn't rent a rental with the airbag missing, so something happened.
You would assume that, correct. Now, he didn't connect the two apparently at the beginning because he claims he didn't find out it was a rental car till later because he didn't check the information that came back, but that information was available to him.
So you also, and I don't mean to interrupt the flow of your events, but let's assume that and I'm speaking for myself, agree that this officer just went beyond the purpose of the stop, which was a traffic infraction, and you have persuaded me that there was a constitutional violation. The problem that I have in this case is that there was evidence and testimony that this officer intended to tow the car because of at least the lack of insurance and perhaps the lack of a driver's license, and there was evidence from his superior that suggests that that was a policy of the law enforcement agency. And if we credit that evidence, then wouldn't this contraband that was found in the car, regardless of the violation, have been inevitably discovered?
No, I don't believe so. I don't think now the court didn't ultimately did not decide this on an inevitable discovery.
We could affirm on any ground.
Oh, I understand, Your Honor, but
Why isn't that a ground on which to affirm?
Okay, well, first of all, the government didn't produce any information whatsoever to verify this idea that he ever intended to tow the vehicle initially. This is the first time that information came up was at the suppression hearing. There was nothing in the record that indicated that he was going to tow the vehicle because of that. In fact, the reason he indicates in his police report is when he was confronted with it was because of the nervousness of Mr. Bowling. He decided to get the people out of the car.
Didn't the district court make a finding that, in fact, the officer intended to tow it, and that was, he didn't say, the district court judge didn't say that would have inevitably led to the discovery of the contraband, but said that was a basis for extending the stop?
Well, I mean, the court in their conclusion indicated that there were the reasonable suspicion that gave rise was the court referred to that as well, but he ultimately said that there was reasonable suspicion.
Sure, but to pick up what the chief said, the court made a factual determination that it was the policy of this police department to tow all vehicles, did it not?
He acknowledged that testimony was...
He made a factual determination?
Well, I guess you could say that, that this individual testified to that. However,
Okay.
that would be
Is
contrary...
Is that factual determination clearly erroneous?
It is, because that
How?
would... That would be,
The officer testified to it? His supervisor testified to it? How is it possibly clearly erroneous to credit the testimony of the officer and his supervisor?
because that is not the intent of the law in West Virginia with regard to a certificate of insurance.
Let's posit that I believe you that West Virginia law would not have required the vehicle to be towed. I think maybe you have a plausible reading that West Virginia law does not require towing in this situation. But that's different from whether Fayetteville has a policy of towing vehicles in this situation.
I think it's more than that in terms of whether or not the policy, what he testified to, it is a policy to tow a vehicle without insurance, okay? West Virginia has a law that requires you to carry a piece of paper in the vehicle that is a certificate of insurance. The presence or absence of that certificate of insurance is no indication, is not necessarily an indication that you do not have insurance. If you don't have that certificate, what in several different contexts the law provides, you have an opportunity to bring the certificate in, whether it is to a court hearing or to a court.
You have an opportunity to produce it to defend against a criminal charge. That makes sense. But the flip side is the officer, you agree that it is illegal to operate a vehicle in West Virginia without insurance, right?
It is.
Okay, so I pull over a car and I say, do you have your insurance? And the person says, no, I don't. And now the officer says, well, now I don't know if I let you drive away. You're going to be operating a vehicle without insurance. Now, of course, you're going to tell me you have insurance, but with all due respect, people tell police officers things that aren't true literally all the time. So a police officer doesn't have to take your client's uncorroborated word that he has insurance. So the officer says, well, given that you don't have insurance and given that it's illegal to operate a vehicle without insurance, I can't let you drive this vehicle away because I don't currently know whether you have insurance.
But he never made a determination that he didn't have insurance. He made a determination that there was no certificate of insurance. He received back that he ignored. He received back when he called the registration in, he received back information that this was a rental car. It was an enterprise rental car. The rental car companies are required to maintain insurance in the state of West Virginia on the vehicles. And they do. There's no requirement that an individual renting a car legal requirement that an individual renting a car has to maintain separate insurance. Now, they won't rent it to you, likely, unless you do, but that's the rental company's decision. But they insure the vehicle. So there was insurance on this vehicle. The question is, did he have proof of the insurance? And that is the four corners of what's happening in this particular case.
Can I take you to the retention of the phone issue? Because I have some questions about that.
Okay.
Did your client ever ask for the phone back?
Well, my understanding.
Did he or anyone on his behalf ever ask for the phone?
I will represent to the court I did not represent him initially, and I have no information that his prior counsel made such a request, and he was incarcerated.
And I presume
he did
you
not
agree-
make one directly.
And I presume you agree that the government does not have to, and in fact probably can't, give a phone back to someone who's incarcerated.
I agree with that.
So what was the government supposed to do with this phone?
Well, I'm just. I think in the end, ultimately, with the court's decision in this particular case, I think this phone argument goes more to my due process argument, and I would acknowledge that under the circumstances, he did not ask for the phone back, and I cannot represent to the court otherwise. I don't know what actually happened with his other attorney, but I have no information, independent knowledge that was ever requested from the police. But they did hold on to this, and the manner in which they obtained the search warrant on that phone was outrageous. I mean, they have all this false information. These are flat out lies. They can say what they want about clerical errors. These are lies. On the first one, I assert that they were lies that they knew or should have known were untrue about the premises that they were searching. When they submitted a search warrant for the cell phone the first time, they included all the same information, all the same lies that enhanced the appearance of the necessity of the search warrant and to raise probable cause. They say it didn't go without it, they could have had it nonetheless, got the search warrant nonetheless, had probable cause. But why did you put it in there?
Because so let's say what you said lies regarding the search, I guess, of the search of the house.
Of 117 Keystone Drive.
Yeah, how many people were living there and all of that. If that's all deleted, would they still have probable cause for the search of the phone? Considering the phone was in the car, the phone was recovered from the car.
Correct. I mean, I can't say, the magistrate may have determined that there was probable cause with that. He may not have. I don't know. I don't know what the magistrate would have, what decision he would have made if they left all that information out with regard to the phone. But nonetheless, it still goes to the conduct of the law enforcement in this particular case, the lies on that affidavit. Now, on the third, they did the same thing. Once again, they include false information on an affidavit. This is consistent with what's been happening throughout this case from the very beginning, with withholding of evidence and delay in producing evidence. There was a poll cam. I didn't know that there was a poll cam present until in October of 2022, just prior to a scheduled trial. This is the first time it came out, and it came out because of some notes from the ATF that indicated there was a poll cam.
This was not on the U.S. Attorney's Office. I spoke with the U.S. attorneys. This is information that the U.S. Attorney's Office was not receiving. And he looked into it and said, well, there was a poll cam, but it didn't record anything. Well, turns out it did record stuff because Agent Bullard testified that he reviewed information on there, and initially I determined that it was recording something because in his search warrant affidavit he had a picture that was obviously taken from that poll cam. So he didn't produce the poll cam. That was pointed right at the area where Mr. Jordan's apartment is, where the guns were found. No guns were found on Mr. Bowling. No guns were found in his apartment. Everything was found in Mr. Jordan's apartment. What you have to go through the parking lot. It would have showed anybody coming and going from that, including Mr. Bowling. There was only one way in. That would have been evidence that we could have used to show either somebody carrying it in or Mr. Bowling not. There was also a DVR that they got from a neighbor that had a security camera pointed right at Mr. Outside their house, which is pointed directly at Mr. Bowling's. May I continue? My time is.
Your time is up. You've got some rebuttal.
Okay.
Thank you very much, Mr.
But just in case, I would just note that the actions of law enforcement are atrocious in terms of the due process argument as well.
Thank you. Ms. Harold?
Thank you, Your Honor. May it please the court, Jennifer Harold on behalf of the United States. This court should affirm the defendant's conviction. The court did not clearly err in any of the factual findings or misapply the law regarding the defendant's motions to suppress. He properly denied a Franks hearing and in reality held a Franks hearing in order to determine that he should not have had a Franks hearing. There was no abuse of discretion in denying the motion to strike the juror for cause. There was sufficient evidence to find constructive possession at the end of trial. And he properly found that the staleness argument regarding the phone was insufficient to suppress it.
Ms. Harold, can I just, you're a lawyer who represents people and you're not responsible for all the things they do. I was in your position or an analogous one at one point. I hope something very bad happens to a person who submitted repeatedly false statements to a court and got a search warrant based on them. That is completely, I just deeply hope and assume that severe consequences have been taken as a result of literally saying things in affidavits that were flat out false.
So I was not counsel on the underlying case, so I don't know exactly what repercussions may have happened, but to be perfectly frank, I agree with you, Your Honor. These search warrants, I would never have submitted a search warrant with this kind of information. It was exceptionally sloppy, cutting and pasting errors.
That is the very most generous description.
But the court was correct in denying motions to suppress. With regard to the residential search, the information was based off of the information that Special Agent Bullard had at the time from a CI. He had taken steps to try to confirm whether there were other individuals residing in the home. And the court credited his testimony.
Can I just go back? So conceptually, I felt I needed to say that because until I said that, I was not going to think about anything else during your argument. But can we go back to the prolonged? So the unnecessary prolonged. So here's what feels to me like a critical question in the district court. So the district court's idea, and maybe especially the way the district court thought of this, which is the stop wasn't unnecessarily prolonged because we had to wait for the tow truck. There was no tow truck. Okay. Does that not necessarily entail that if at some point during the stop, Mr. Bowling had said the following: I understand that you're not going to let me drive away because I don't have my insurance, but I'm going to call my friend and ask him to come pick me up, and I'm going to leave. On the district court's theory, the officers would have had to let him leave, right?
Yes, Your Honor.
Because if the only reason to keep this all going is we got to tow the car, if Mr. Bowling wants to peace out, Mr. Bowling can just peace out.
Yes, that was the finding.
Do we think that is a plausible interpretation that the officer was actually going to let Mr. Bowling peace out even if he tried to?
It's hard to know what the officer would have done. This was...
As a descriptive matter about the world, it strikes me as extraordinarily unlikely that this officer was going to let Mr. Bowling just leave.
It probably was, and I think that's in light of the remaining circumstances, because he also, the towing issue was one issue. He also had reasonable suspicion at that time. And I think if Mr. Bowling had said, hey, I'd like to call someone to come pick me up, at that point, the officer thought he had reasonable suspicion. The district court found that he did, in fact, have reasonable suspicion. I think he would have done that search prior to letting him go.
So, let me pause on this. I definitely agree there are facts that suggest weirdness. We talked about that, I guess the link I'm missing is I definitely see facts that something is kind of weird. I'm not sure what crime is there reasonable suspicion of, right? I'm really struggling. We've got a few circumstances. I agree, they seem a little strange, but I literally have been mentally trying to figure out what crime do these make me think is going on? And I am candidly having trouble.
And that is one thing with reasonable suspicion. Usually you don't know
It's
what
not
the
reasonable
crime is.
suspicion of weirdness, though. We don't allow you to keep people on the side of the road for half an hour because of reasonable... so let's take the classic case, Terry versus Ohio, right? So Terry versus Ohio, think about the officer testifies in Terry, and think about the Supreme Court says, this seems like these guys might be casing the joint. Do I know they're casing the joint? No. Do I even necessarily have probable cause? No. But this pattern of weird behavior I observe leads to a fairly confined number of hypotheses of things that are identifiable crimes. And I think most Terry cases that I'm aware of are like that, right? Maybe these people are drug dealing. Maybe these people are this. I don't know what crime this creates reasonable suspicion of.
And it's not in the record, Your Honor. The court didn't require this further information, but
I don't think the officer didn't identify a particular crime either. He just thought things were weird, suspicious, but he didn't articulate what his suspicion was.
He didn't articulate, he articulated many different possibilities. But in this particular location, there is often drug trafficking. And when he said that the route that was being taken was unusual, I'm sure he wasn't just saying, oh, this is, obviously someone would have driven the other way. Driving on a more rural route is a frequent habit of individuals who are trafficking drugs. Now, that's not in the record. But that is in the back of the officer's mind. It doesn't make it unreasonable that one of the things that he was thinking could be at issue was drug trafficking. And he mentioned that as one of his several things he was concerned about. So are a lot of these things weird? Yes. The airbag in a rental car being cut out, as Chief Judge Diaz pointed out, Enterprise is not renting cars with airbags cut out. And if I've rented a car and I'm in a car accident, I'm not going to cut it out and just keep driving it around. I'm going to go get a new rental car. So those are suspicious things. In fact, that would be suspicious information that perhaps...
Suspicious of what, though? They got in a car accident?
And didn't report it to the Enterprise rental company.
It's not a crime. Maybe it's a breach of contract, but it's not a crime.
They probably also did not report it under the circumstances to law enforcement, because law enforcement probably would have...
Is it a crime to not report a car accident to law enforcement?
If there's property damage.
Can I ask you about a factual question that is just confusing the heck out of me? How do you explain Officer Farley running his learner's permit number over an hour into the stop when he allegedly never received a license?
Well, the court credited that his testimony that he did not receive it.
Yeah, but with all due respect to the district court, I don't know how to square that factual finding with the fact that he ran the learner's permit number.
He ran the learner's permit.
Where did he get it if he didn't get it from the license?
At that point in time, they had placed the defendant under arrest and likely searched him incident to that arrest. They had searched the vehicle. This was 2 years later, and Officer Farley did not remember how he got it. He knew he didn't have it at the front end. He could have easily found it during that search. If it was present on the person of the defendant or in the vehicle, it would have been found. And so given the timing of when that was done, after a search had been completed, after the defendant had been placed under arrest, there were a number of reasonable conclusions as to how he obtained the learner's permit up front. And when you think about the way he conducted this, he said, I asked him for his information. He did not provide it to me. I got him out of the car. We began talking. He gave me the name of the backseat passenger, so I radioed in that name. So right now he has a person who's refusing to give him identification. He might not trust that particular name if Mr. Bolin gave him the name. There's actually no testimony in the record as to whether he even stated his name. He does get a name, and he runs it for someone in the backseat. So none of that is an unreasonable action or course of action to take. It's not indication that he was nefariously trying to extend the stop by refusing to call in information. When he got information, he appeared to be calling it in. And under the circumstances, in this case with a traffic stop, there's really 4 different grounds to affirm based upon the conclusions and factual findings of the district court. The defendant testified at the hearing he never turned over insurance information. The court credited that he had not turned over his driver's license. Until those things are done, until this officer can confirm that the defendant can legally operate this vehicle and that insurance covers this individual, which
Did he turn over the rental car information?
he did not, Your Honor. He said it was a rental. He did not turn over any certification or any rental agreement to authorize him. And in fact, if he had, he was not the person named on that rental agreement. But that rental agreement was not turned over.
So then maybe he's in violation of a contract with Enterprise, right? I think I can make a statement about the world that people frequently drive rental cars that they're not on the rental agreement for. Would you agree that's probably true?
I would agree that that is probably true, Your Honor.
And that it's not a crime to, it might be a breach of my agreement with Enterprise, but it's not a crime to do that?
No, it is not a crime to do that. However, it's a very good likelihood that that would violate the insurance agreement between Enterprise. Enterprise's insurance is likely not going to cover non-authorized drivers.
A guy with a learner's permit?
A person with a learner's permit, I believe there's testimony that someone with a learner's permit would not be legally able to operate a vehicle at 3 a.m. because there is a curfew in place. The officer believed it was 10 or 11 p.m. And having driven in West Virginia with a learner's permit, I can tell you that that's true.
Can I at some point, can I take you to the phone? Because I just have a conceptual question with the government's argument. Is it your view that a person who's incarcerated retains no possessory interest whatsoever in the property that was taken before their incarceration? Because that's, I mean, look, as I said to your friend on the other side, I totally agree that when he's incarcerated, we can't give him the phone. But it also seems weird that he has no possessory interest in the phone either.
And I think that's fair to say that it's not zero. It's very minimal. Courts have found it's very minimal. And there is a circumstance. And as Your Honor asked, he could call his wife and ask her to go get it. That would be him having some kind of possessory interest to discuss where the phone ended up. That never happened.
He was too busy calling his wife for other things.
Yes, Your Honor. In fact, he called her to delete the phone.
We could reject his claim here without saying what we would say if at some point during that lengthy period, he, his wife, his authorized agent had said, I would like the phone back. We could leave open what would have had to happen then.
I believe so, Your Honor. We don't need to reach that because it didn't happen. So that is a different case for a different day. But also in this case, when you look at Pratt, there were 2 issues. It was the possessory interest was not diminished for Mr. Pratt, but also there was no good reason given for the delay. They were trying to pick which state they wanted to get a search warrant, and that's not a justified response. This is a situation where the government promptly obtained a search warrant, and the technology was not available for them to search that. But they still had a strong interest in searching this phone. They knew this phone was seized from someone who also had substantial quantities of meth and fentanyl.
This may or may not be in the record, but like, is this the situation? Could you have cloned the phone even if you couldn't unlock the phone? Could you have cloned the phone during this period of time?
I do a lot of phone cases, Your Honor. This isn't in the record, but no. The problem is you cannot, until the software is updated, they cannot even extract the phone. And they can try code breakers. Those often can take months because it is just a random selection. So I have often had cases where we've had to wait for an update.
Pratt said that too, right? Like, or we have cases that say, like, to the extent the government has an interest, they have an interest in the info, they don't have an interest in the phone, so if you can just clone the info, you can then give the phone back.
Yes, and we are in a situation where we could not take that step. You could not clone the phone or extract it to create a mirror image.
Is there a limit as to how long the government could have held the phone waiting for the software update?
I think if the defendant had been released on bond and had a possessory interest, that could come into play.
I mean, you just can't sit on it indefinitely, or, I mean, there's got to be some limit to that, I would think.
And when you think about if the government has they have a good justification for keeping it. Their interest in the information on the phone is not diminishing over time. And the statute of limitations is frankly something that Congress has said, this is when you stop. And I think as the statute of limitations to charge the crime was running, you obviously can't hold it past that. I think if he had gotten out and had his possessory interest available, that would counterbalance it potentially. But that justification for needing the phone in the first place and having a strong government interest in that information, isn't diminishing over time. So I don't think there is a time limit you can put on there when the government does have a reasonable interest in maintaining the phone.
On the phone, I asked him this question earlier. So with the issues with the search warrants, I think we all have kind of acknowledged the issues with the search warrant. Do you still believe, tell me why a government's best argument that there's still probable cause on the search warrant of the phone, the last search warrant?
There is really the false information. It didn't need to be updated. It could have just been taken out because the phone could have been searched. They could have got a search warrant for that phone the day that they obtained it in the car, in the traffic stop, which was before and unrelated to the search of the home.
Based on the contraband that was found in the car?
Yes, there's drugs, there's cash, there's a phone. And the search warrant affidavit articulated the connection between drugs, cash, and cell phones and how those are used in drug trafficking. So if you had confined it to the universe of that, you could have gotten a search warrant. The information about the CI doing the controlled buy just further adds to that. But even that would not have been necessary.
That supports the inference that the defendant is not just some guy in a car that's got drugs.
Yes, and that the drugs were
Someone else's.
to be distributed. I think those quantities are not going to be personal use quantities, but those two pieces of information were accurate. You take out everything else that was admittedly very sloppily included, you still have probable cause. So the search of the phone would have been valid, and I think the court was correct in making that determination, that there was sufficient probable cause, and I would ask that this court agree with that. If the court has no further questions.
One more question. Yeah. The gun in the trunk of the Camry, I think there's an argument regarding is constructive possession of that. What do you have that, I guess, in terms of evidence that links him to the gun?
The gun in the Camry was not the basis of any of the charges. It was, and that charge was dismissed by the United States, so it was solely 404B evidence. And for purposes of that, is there sufficient evidence to have connected the Camry to a conviction? It would be less strong than the evidence of the guns that were found in Mr. Jordan's apartment, but that was not the basis of a conviction.
Thank you. Thank you, Ms. Harold.
Thank you, Your Honors.
With this search, I want to touch on this another issue with this search warrant idea, and a reason that maybe that it's kind of sloppy, and I think it's worse than sloppy. I think that it goes beyond that, and somebody should be held accountable, and I think they should be held accountable in this case. During the trial, it was determined that, or during the hearing, the suppression hearing, this late supplied exit video was significant because at the end of the exit video, they said this search is complete, 1649. Bullard testified that this search took about an hour and a half to perform, that he got over there about 3. In this search warrant, he testified that he included jail calls, and I mean, it's undisputed. I mean, he included jail calls in there. He had the email, we had the email where he got the jail calls. Those were after 3 o'clock in the afternoon. I detailed this in my brief, but I think it's very important. It becomes clear because of the exit video and the time of the exit video and what he testified he did. He got these jail calls. He listened to the jail calls. He drafted the search warrant. He sent the search warrant to the U.S. attorney, who sent it to the magistrate. The magistrate issued the affidavit, the application. The warrant was issued, sent back to the U.S. attorney, and sent to Bullard, who then claims that he conducted this search, receiving these jail calls after 3:30 in the afternoon. He was done at 4:30 on an hour-and-a-half search. The evidence in this case establishes that he had to have begun this search before he had a search warrant. This whole thing stinks with the search warrant. This false information was included in this affidavit because they knew exactly, it was perfectly clear that this was a 4-bedroom apartment and he lived in one apartment or his other ones, but they apply for a search warrant for everything so they can search everything, knowing full well that I'm going to have standing issues if they find something in one of these other apartments. I can't attack it. So they get a search warrant, they go in and they search the whole building, they find information or they find contraband in one of the apartments, and their argument is, well, you can't attack this. Well, they used false information to get the search warrant. They probably started the search before the search. Well, obviously they started the search before they had the actual search warrant in hand, because it's impossible in the time that was listed for him to do all those things and conduct the search. They didn't provide me with the video. They withheld the video of the search. Okay, they gave me the exit video. The other video would have absolutely confirmed this, that this search began before he had the search warrant. I asked if there was one. He said yes. I said, where is it? I don't know where it is. Okay, so they didn't produce that. It's everything in this case stinks from the very beginning. With regard to the route he was taking, I want to say something. There was an argument made that taking a more rural route is what drug dealers do. That's not what he was doing. He was taking the less rural route. That's why that's why Farley thought it was a problem, because there was a shorter route getting off 19, going up a 2-lane road, up Route 60 in the middle of the night. He could have gone back to Charleston that way. What he was doing was headed directly to the interstate, the West Virginia Turnpike, and if you Google it, it's the shorter route Farley referred to. Granted, time-wise, it's the same distance. So he wasn't taking a more rural route. He was on a U.S. highway, driving down a U.S. highway at this time. The timing on the learner's permit, at no time did he ever say that that was recovered in a search. He said it wasn't given to me. He was confronted with it. He could have explained it away, and he didn't say that. He said, I don't remember receiving it at the beginning. But he had it, and he ran it, and he couldn't articulate a reasonable suspicion when asked about it. He said there could have been bodies, there could have been drugs, or could have been anything in here. He was unable to articulate any kind of a reasonable suspicion. I think all of the findings that the court made that found where they found that he had reasonable suspicion are simply, unusual incidents. The car speeding at 3 a.m. There were 2 officers on this highway at this time of the morning. It's a pretty heavily traveled road. The fact that he's speeding, okay, he was breaking the speed limit. That's not unusual. We discussed a driver's license, registration, and proof of insurance, the hole in the steering wheel. I don't deny that these facts occurred, but they still do not constitute, they don't rise to the level of the judge's legal determination that constituted reasonable suspicion. He did talk about nervousness. This court has said over and over, nervousness is not a good indicator of criminal.
I need you to wrap up because you're over your time.
Of criminal activity. But he noticed that nervousness after he had him out of the vehicle at 3 o'clock in the morning, standing behind his car when he wasn't pursuing the purposes of the stop for 25 minutes. Who wouldn't be nervous in that particular circumstance? I don't believe there was reasonable suspicion, and I would just rely on my arguments submitted in my brief. Thank you.
Thank you, Mr. Yost. Mr. Yost, I note that you're court appointed. I want to thank you for taking on this appeal, which you've ably presented, and the government also, Ms. Harrell, was ably represented here this morning. Thank you both for being here. That wraps up our term for the week. I'd ask the clerk to adjourn. Court will come down and greet you and adjourn for the week.